Hello there. Right, I'm doing this video because I feel that it's something that needs to be debated about, and for the information to get out there. It's all public information, and so is out there. It's just not sure anyone's ever looked at it. So if you like this video, please share it. Please like it. I've disabled the comments on it, so you can't comment on it. But please do what you think's best with it. I'm sure that there's information in here that you might find interesting, and please research it yourself further. So the video is about whether, as I do believe, there's an institutionalised discrimination within the family courts. I know it's a very touchy subject. So what I want to point out, this is a review that I have done. It's from only the publicly available resources. So this means the resources that the courts themselves and their agents such as CAFCASS and legislation.gov have published. I mean, family proceedings, if you're not aware, are private, and so everything with regards to family proceedings are private, and so nothing to do with family proceedings are within this. This is purely a review of the information that is publicly and widely available from their own websites and reviewing it. Okay, so if I find that there's stuff within their actual publicised documentation which is, how can I say, discriminatory, then I think this helps to show a picture that there is actually, in fact, discrimination within the actual system itself. So, I want to make sure that you're aware that I am just a father. Yeah, I have no legal qualifications. I haven't been legally trained. I just care a lot about these subjects. Okay, and I really hope, in all honesty, that this sort of information manages to get to the president of the family division, who's a Sir James Mumby, in the hope that he will then look at it and see it, and I would be very happy to talk to him directly about these sort of things, because what I believe is, as the court puts it, it needs to protect the best interest and welfare of the children, and I feel that the institutionalised discrimination within the systems are clearly therefore not protecting the best interest and the welfare of the children. So I've written quite a lot. So all this document that I have written, with all the supporting evidence, i.e. the outtakes from all the official documents, I'm going to include in a link within the blurb so that you can download it and read it, so that you can take it in. I mean, I'd be really happy to find someone who is actually legally trained professional who specialises in discrimination and the equality law to have a look at it so they can comment. So let's get a feel of this. Now, within a judgment by the President himself, which was in the Court of Appeal, he's made quite a remarkable statement, okay? And the judgment is with regards to Regards B, a child, 2017, EWCA, CIV 1579, and it's at paragraph 11. He reports about the idea of the competencies and integrity within the family courts. So, what he's written or said was, the other, I fear, has to do with the widespread distrust in too many quarters of the competence or even the integrity of the family justice system and of the professionals involved in it. Here, of course, it is the existence of the mindset rather than its foundation in reality which is the driving force. Okay, so I hope that this review of their own publicly produced documents will help to show that this is not so much a mindset of the public, because obviously he knows that the public thinks that there's a discrimination in there, but I think perhaps because they're in the system themselves, they can't see the wood for the trees, as it were. So I have specifically reviewed a specific section, which is Practice Direction 12J, which is about domestic abuse. And I've also done quite a heavy review on it also about CAFCASS, who is the court-appointed social services for the child. But they are as far as I'm concerned, they are technically the same thing as the court, because the court has a set of rules which are mandatory, called practice directions, and they specifically keep referring back to CAFCASS, and the courts and the judges have to listen to their input and often take note of exactly what CAFCASS have said. So, if we're talking about there being discrimination, we better start having a look at what is considered discrimination. So, to do this, let's have a look at the Equalities Act 2010, right, and its relationship to within the family court system, shall we? So, under Schedule 19 of the Equalities Act 2010, there's a consolidated list from April 2011. The courts and CAFCASS have a duty to uphold the provisions of the Act, and they're specifically named within this section. So, if they're not actually upholding the Act, then that's quite serious, especially as they're named within it. So, it's quite an encompassing document, so you'll find that I've only included the snippets of the Equalities Act within the appendix in the attached document. So, what does the Equalities Act 2010 have to say? Well, it says, there's a public sector duty regarding socio-economic equalities. So, do we think that the courts are upholding that? Well, I think maybe they're not. Not because they're consciously doing it, but there's clearly socio-economic inequalities. So, if one person has more money than the other, they're able to get lawyers, barristers, and so on and so forth. Whereas possibly the other representation is being a litigant in person, and therefore they're doing it on their own. So there's a clear difference in equality there that's from the beginning. Now, with regards to equality, also there are protected characteristics. These are age, disability, gender assignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, which is basically gender, and sexual orientation. Okay, and of course this means that there is a duty that you should not discriminate on these characteristics either directly, indirectly, or by a combination of characteristics of the discrimination. Examples, for directly, person A treats person B less favourably than person A would treat others. That's an example of how you directly discriminate. Indirectly, which is a little bit more complex and convoluted, but it does happen out there, where person A applies to person B a provision, criteria or practice which is discriminatory in relation to a relevant protected characteristic of B. So basically, because of one of the characteristics, you're setting a bar that has to be reached. Yeah, a provision before you provide a service or supply material or whatever. Yeah, it then goes on. A provision, criteria or practice is discriminatory if it puts or would put persons with a protected characteristic at a particular disadvantage when compared to those without the characteristic. So what this is saying is, if you have a large group of people and 90% of them are a protected characteristic, therefore if they have a strong correlation with something else, say you are, I don't know, a man, and because you're a man, you would normally drink beer as opposed to wine, yeah? And if you're a woman, you'd normally drink wine as opposed to beer. So if you put a condition on that only beer drinkers can attend, therefore you are discriminating indirectly because of this grouping there is in the sheer majority of beer drinkers are men compared to women. So, however, this is quite hard to interpret, and so setting this, it can also mean that someone isn't actually, a group of society physically isn't able to achieve this. For example, maybe women, you can only go toilet if you can stand up and go toilet in a urinal. That could be forms of inequality. So, for an example that I think is relevant within the court system, Society has generally put the man as the financial provider in the relationship and the woman as the homemaker. Now this is given that it's a normal heterosexual relationship as opposed to a normal same couple relationship. So I'm just basing it on a heterosexual relationship for this particular example. And yes, I understand people of the same sex are together, and I'm not, but it's just an example. Alright. So society has generally put the male person as a financial winner and the woman as the home giver caretaker. And so if you were to discriminate on whether they are the financial provider or to discriminate on whether they are the care provider, you have then put one of these groups at a particular disadvantage because it's associated with the fact that primarily homemakers are women and primarily financial providers are men. Right, so this situation gets even worse when you go through divorce because initially the roles, they're somewhat voluntary and people enter them without realising, and it just is the way it is. But if things change, for example, the woman gets a much better paying job than the man, then the roles can switch, and so there's an opportunity for it to change. Yeah, but once you go through the courts proceedings and that, then you tend to find that they like to stick with the status quo. And so if that is what the situation was to start with, they enforce it. Yeah, and once it's enforced, you're never likely to change it. And therefore it's no longer voluntary and it's a mandated section. And then if it's once they've mandated that this is your role, to then discriminate on that basis, well, that would just be wrong, surely. So, I think that really comes down to what the courts describe as residential parents and non-residential parents. So, now there's another form which is the combined. And this is where you either directly or indirectly discriminate because of two or more of the characteristics that have been previously mentioned. But you wouldn't be discriminated on a lower combination of them or if you only had one of the characteristics. Within the actual legislation, it also says that you're not to harass. Now, harassment is basically conducted to a relevant protected characteristic that has the purpose or effect of creating an intimidating, hostile environment for that person. Now, people have their own personal opinions, yeah? So if you feel that you're discriminated against, then this is possibly an option. So they have tried to then describe it. So, in deciding whether the conduct has the effect, the following must be taken into account. The perception of the one harassed. So if you are the one that's being harassed and you feel you are being harassed, then you most likely are being harassed. And this is subjective to the individual. Yeah, so, people don't all feel harassed by the same things. We are all different. Yeah, something that will harass one person won't necessarily harass another. You'll find that people with very low empathy scores, who tend to be sociopaths and that, will then obviously not be harassed so much and feel that conduct is much more suitable than others. The other circumstances which are within the case, so it could be a cumulative effect, yeah? So one little thing might not be considered harassment on its own, yeah? Whereas it could be just the straw that breaks the camel's back. It could be a little niggle here, a little niggle there. But the cumulative effect then comes into play, and that's what the other circumstances are. So, and then the third one is whether it is reasonable for the conduct to have that effect. Now again, this is a very subjective matter because it depends on who believes it's reasonable. Yeah, a sociopath will think something is reasonable, whereas someone with a very high empathy score will think it's unreasonable. Those who have been subjected to harassment will more likely be more susceptible to these things than those who haven't, and notice it more and possibly take even more effect from it. But this is where this part gets very difficult. Who is to say what the effect was? I do quite like the fact that it's the perception. The only person who can actually say who feels harassed is the person who felt harassed. So it then goes further on that you're not to then victimise people. So it says, a person A victimises person B if person A then subjects person B to a detriment because B does a protected act, or A believes B has done or might do a protected act, or it then goes on to describe that what it means by a protected act is basically the reporting of of being discriminated against. So, for example, me making this video saying I believe there is discrimination within the law system, as it were, then to harass or victimise me for doing so because I'm trying to instigate public debate would then be a victimisation of me for making these points verbalised, as it were. So, that's basically what the legislation of the Equality Act 2010 is saying. Now, just so you're aware, there has been other legislation. Originally, there was like the Sex Discrimination Act 1975, which virtually covered most of these items as well. However, it's been repealed and a lot of acts have all been pulled into one act, into the 2010 Act. So, we've then got Section 29 of the Equalities Act is all about describing various companies which may, or organisations which may discriminate on you. And Section 29 is all with regards to the provision of a service and tries to relate them in various manners on how it might be seen as discriminatory. I think the whole of Section 29 of the Equality Act needs to be considered because basically the court is a service provider. It's trying to service you by providing law, justice and the welfare of your child. Yeah, and the organisations which it uses, such as CAFCASS, are service providers. It goes on about Section 32 then gives ways and examples of trying to interpret about service section, and I think 32.3 is a reference to the provision of a service includes the reference to the provision of a service in the exercise of a public function. Therefore, court service is a public function. Therefore, it needs to be considered under the service section. The 32 part 7 then refers to a form of discrimination, yeah, by the service provider not providing a person with a service. So, for example, the service provider not providing the person with a service of the quality that the service provider usually provides to the public. So, if you are of a protected characteristic, i.e. sex, sexual orientation, marriage, yeah, and you feel that you are not being provided the same level of quality of service as other people are, then they are failing in your duties. Next one is the service provider not providing the person with the service in the manner in which or on the terms on which the service provider usually provides the service to the public. So if you have a particular characteristic and you feel you're having to jump over more hurdles to be heard, to be seen, then they're failing because they are discriminating against you because they're not providing you with the service in the same manner they provide others. So, and they're making you have more terms. So, in a family court situation, the services provided should be identical to both parents by the court themselves and by CAFCASS. Failure to do this, for example, if you deal with CAFCASS, you'll most likely have to do an interview with them. Yeah, so if asking different lines of questioning during the interview, where, for example, they're obviously going to have to be interviewed by the same person to keep continuity, but that means one parent is going to be talked to before the other parent. So if you talk to parent 1 and then you talk to parent 2 and you start talking to parent 2 about your conversation you've had with parent 1, then that's not providing the same level of service. Yeah, you are treating them differently. Because the first parent's not able to then remark on the comments the second parent does. So, just going to take a little break from here. Right, okay, back again. So, where was I? So, I think CAFCASS is integral to the court system because they are directed through practice directions to be consulted, and quite a lot of their recommendations are basically considered to have to be enforced by the court, and it's mandated by the practice directions. Okay, so considering them separate entities is somewhat of a farce, so have to make sure that I include them within this. And so if people are not aware, CAFCASS is the Specialist Court Social Services. They're there supposedly to look after the child, okay, and look out for their best interests. Okay, so they're supposed to represent the child and make recommendations to the judge. But because of their mandate, they are often, therefore, the investigator, the interpreter of the information, the jury, and the judge all rolled up into one, because they do the questioning, they formulate the answers, they make the recommendations to the judiciary, and the practice directions basically tell the judiciary that they're supposed to listen to them, and therefore basically what they recommend should be done. And so this means that if they are problematic, then that's clearly going to be putting quite a lot of children at risk. Yeah, there will be the welfare of thousands. Just to sort of get a picture of this, CAFCASS's own research, which is titled Private Law Cases That Return to Court, a CAFCASS study, November 2017, which shows during the period of 2016 to 2017, there were 40,599 court applications. That's just a family court. So that's a lot of children all getting caught up within this system. Yeah, so if there's discrimination within this system, thousands, if not tens of thousands of children are then being discriminated against by proxy of one of the parents being discriminated against, which is clearly not in the child's best interest, and it's not good for their welfare. I will just also like to say, this is CAFCASS's own research, but considering the information I'm then going to provide, which I think helps to show that due to their resources, there is a level of discrimination within the organisation, that any report that they do, it needs to be considered with a pinch of salt, because they're going to set the basis of it. They're going to set the assumptions, yeah? I mean, this particular report, although there were 40,599 applications, they decided to do it from a very, very small sample. They did it from only 100 cases. That's 0.2% of all of the cases. And then they extrapolated the data. Okay, so from a statistical point of view, that's not that accurate. That's not that great in statistics. I'm sure there'll be mathematicians which can help to do it. But also, it was the people they chose, a representative cross-section of society. Or whilst they were picking their sampling section, was there a randomness? Were there certain criteria they might have provided? If there's discrimination at an institutional level, you may have found that they happened to pick cases that they could manage, deal with, understand better, or feel they understand better, and it can then sway the result. So on such a small sample, you could find that actually the statistics are rubbish because of the assumptions that were first set out when making the investigation. People always forget how important it is to analyse the initial assumptions on your selection process. Were all these cases from one particular region? Were they all from one socio-economic group? There's 1,000 different ways you could potentially bias a set of results on any research, and therefore before you take any research at face value, you need to really drill down into the methodology behind the research. So, this information is all publicly available on CAFCASS's own website, because they are currently offering what they call the Transparency Information Policy, which is detailed on their website, and in the document that I produced, I've given you the hyperlink so you can find it. But in short, they are trying to appear to be as open as possible, yeah, because I think they realise they have a bad name. Lord Justice Sir Mumby, in his extract from that judgment, says that there's a widespread distrust, and therefore I'm trying to show why. And also you will find that there's quite a lot of blogs out there, articles out there online, which are saying that there's discrimination. Some people manage to make the news and that at times. So, but it does mean there is the benefit of their resources are openly available to the public. Like me, I'm just a very concerned father who actually has a lot of great time with his daughter. But I do worry about her, and I worry about all the other children within the system. So, this review is using only the public information. It's not using any personal informations about personal cases. So, just have to quickly get down here because I'm going a little off script as I'm doing this. Yes, so it's very hard to get a gauged feedback because of the private nature of cases. There isn't a great feedback system because basically they're private, so people can't talk about their individual cases. So, but I believe if I can show that the tools that these organisations are having to use to do their analysis and to write their reports are themselves discriminatory, then this means that there is an underlying discrimination because no one within the system has picked up this discrimination, and it's producing discriminatory results because the tools you're using are discriminatory. So, it's quite shocking with what I will show you, and from the fact that this is a situation where it's all about courts and they're all about legal professionals. And this is just my interpretation based off of the Equalities Act 2010. And I include all my resources that I have found, which you can go independently check on their own websites and from the legislation websites, the .gov.uk websites. So let's talk about the very first set of actual resources. I've talked about a piece of research they did. Now let's talk about one of their resources. Okay, so this is CAFCASS resource, Practice Pathway, a structured approach to risk assessment in domestic abuse. Now, this document appears to have several issues. The first one is they ask you to use the Bernardo's Domestic Violence Risk Indicator Matrix. Now, they're saying this is a tool you must use. Okay, great. I believe there's quite a serious problem with this tool, and I will come to that a little later on because this is a tool they're using, so it adds to their resource list. Sticking with the practice pathway, later on in the document, it quotes the year 2011 research, which then clearly identifies the perpetrators as men and the victims as women, with the comments of invocation of male privilege and last resort by the woman victim. They follow up in a bold heading later on in the document, quite clearly. Note, currently we only offer commissioned programs for male perpetrators of domestic abuse, so the following information is weighted in this regard. Now, it's quite shocking if you stand back and look at it. They have just blatantly put out an admission of guilt on this piece of paperwork that they are not providing a service on an equal basis because it's only available for men. This is not available for women. So they're clearly failing the Equalities Act on their provision of service and the discrimination based on the sex. I'd also like to point out that this is also then in violation of your sexual orientation, because it's assuming only a heterosexual relationship can be domestically violent. It also admits to some more of the bias, and that it is biased in the fact that they say this information is weighted in one direction. So, thank you, CAFCASS. You produced an official report which has basically said, yes, we are discriminatory and we are biased in one direction. Great. So, now, the thing that it's saying about the commission programs is called a domestic violence perpetrator program. Yeah, and it comments in this practice pathway, then make 3 gender references to father, and then this is obviously discriminatory on sex and sexual orientation again, with the presumption that only a male is able to be domestically abusive, whereas women can quite easily be domestically abusive. Right, we'll go back to the CAFCASS resource, which they are instructed to use, of the Bernardo's Domestic Violence Risk Indicator. Now, it looks pretty not terrible when you first start looking at it, but then, if you read it, it has a subtitle, Assessing the Risk to Children from Male to Female Domestic Violence. Therefore, this whole form is based on a gender disposition, which is discriminating on both sex and sexual orientation. Okay, so the fact that this tool is used is obviously pre-biasing any user into this mindset. And so we're now going to move on to the CAFCASS for assessing whether a DVP is appropriate. Yeah, now this is a very brief document, but in paragraph D, they refer to the perpetrator as he, and in paragraph E, the victim as mother. So again, this is clearly showing that they're discriminating on the sex and sexual orientation of those who are being assessed. Next we have the CAFCASS resource on the Safe Contact Indicator. This checklist form is less directly discriminatory to any individual, but the way it is laid out, it has a list of positives and a list of negatives. Okay, and basically you answer the questions, and answers in one side means that's positive, answers in one side means that's negative. However, it is not always the case, because they keep using the words non-residential parent and residential parent. Now, as we've already said, this is a form of indirect discrimination because of the particular disadvantage when compared to those without the characteristic. So, the form and its layout is therefore indirectly discriminating. Now, the other part of the problem is it's assuming that the abuser is the non-residential parent. Now, there's quite a lot in the news about implacable or implaceable hostility and parental alienation. And actually, the abusers in most of those situations is actually the residential parent, not the non-residential parent. So their whole form falls apart because it assumes that because the child is living with this person, they're not abusing them. And that's not always the case. This is where a lot of their problems are then having this issue. So let's move on to the tools for assessing coercive control. Coercive control is part of domestic abuse. So this resource is suggesting that you should use the Woman's Aids Toolkit for talking to young people about coercive control. So I'm going to talk about that particular piece a little later on, but they have said use this resource, and it was produced by Women's Aid, and I'm pretty sure you can guess it is highly gender specific. And because it is highly gender specific, it is discriminating. Anyway. So, by the use of using that form, that whole document is not very good. It then continues with a table for assessing perpetrators and victims. And yet again, this form is built on the premise of a male being the perpetrator and the female being the victim. And within this table, it makes references to his, him, himself, when talking about the abuser, and person handbag when talking about the victim, all of which is implying a gender. It's also implying that it's a heterosexual relationship rather than another sexual orientation. So, we'll now move on to the CAFCASS resource which has been recommended for the Women's Aid and Avon Controlling Behaviour in Relationships. So, as you can imagine, by the virtue of its creators, it prioritises women and placing the importance between mother and child rather than parent and child. The companies are quite clear in their policies. These charities are quite clear in their policies. On the back page of this is the company's logos, and these are the strap lines on the bottom of their logos, which says the company for women, which is Avon. Okay, so understand, mainly makeup, mainly for women. Okay, alright. But when it comes to Women's Aid, it says, until women and children are safe. So, what about men and children? Why is it always the woman and the child? Why is it not parents and children are safe? Yeah, I understand you are Women's Aid, but you are propagating that the child should always be with the woman. So that is a form of discrimination in itself within your own strapline. Yeah, if you would have said until women are safe, great. Then you're only identifying the one, and you're clearly saying it. But what you are saying with this strapline is the children need to be with the mothers. You're taking no effect on whether the mothers are the abusive people within the relationship and the people who are abusing their children. Now, I know it's unusual for the women to do it, but it does happen. Let's just think. Moira Hindley. There we go. There's a prime example of a big name of a terrible woman. So, the document uses various examples within it, which always shows a female as the victim, and it always shows a male as the perpetrator. Never shows a female as a perpetrator against another female. So it's being sexual orientation discriminatory, but it is enforcing the gender roles of female is a victim and a male is a perpetrator, and that is not always the case. So the women have as much ability to be a perpetrator of domestic abuse as men are. Apart from these things, and the overtones within the actual document, a lot of the document is actually really well written. Okay, but there is a general feeling, ethos behind it. The fact that only the examples are these ways and that. So, don't get me wrong, I actually like Women's Aid. They've helped one of my friends quite a lot, yeah, and it's great, but I think that they need to be more sociably responsible. They do clearly have quite a lot of impact, and I will talk about how they've impacted the legislation later on, and they need to be more socially responsible, with also pointing out, yes, we need to protect women, but we need to protect men as well. We need to protect children. Yeah? The assumption cannot be the man is the perpetrator and the woman is the victim. If you start on that basis, it's not a fair system. It's not just. It is totally discriminatory. People have as much chance to be the perpetrator or the abuser, no matter what gender you are. Now, I think considering I have just looked at CAFCASS on this one issue of domestic abuse, yeah, and I have shown 6 publicly available resources from their own website that have all been written around the subject of domestic abuse, all of which are clearly, as in my eyes, being discriminatory as opposed to their requirement from the Equalities Act. So, I know the Equality Act is only 8 years old, but it's not the first set of this sort of legislation. As I've mentioned earlier, Sex Discrimination Act was 1975. Therefore, none of this should have ever made it into any of these. Now, I think if it were possible for participants within private law cases to talk more freely and openly about their experiences, I think there'd be quite a lot of data that could then help assist with these this management of this public service. But they're not, so there isn't the ability for this data to be gathered. And I'm definitely sure you would get reports of how people within the system feel they have been treated differently from each other by the provision of this service. So I hope that's been quite informative about CAFCASS on this one section. And if they're being discriminatory on this one section and it's institutionalised, the likelihood is in all the other sections there is going to be an undertone of discrimination as well. Right, hello. As I said, I'm doing this review from public information on whether there's discrimination within the court system, the family court system, and I'm specifically focusing on the section with regards to domestic abuse. So, I've spoken about CAFCASS and their resources, and I'm now going to move on to the family court section, which is Practice Direction 12J, which is specifically all about domestic abuse and the harm this does to the child and the parenting abilities of the victim. So, this whole thing means that it is heavily reliant on CAFCASS, and they're mentioned quite a lot within the actual practice direction. So this obviously has the issues with all the resources I've just mentioned previously. Now, given that the courts themselves are actually supposed to uphold the law, yeah, and the Equalities Act 2010 is the law, you'd think that Practice Direction 12J would therefore be written without discrimination in it. Yeah. In the resource I include highlighted copies of the full Practice Direction 12, which is available online from the official government website. It's publicly available to everyone. Okay. So, now the Practice Direction 12J has actually recently been updated. It is now currently 2018. So the one that's in the appendix is what was publicly online in January 2018, but the actual 12J was older, but it was reviewed and it's just been republished in October 2017 after the COB review. So it has actually been updated, and this is after the update. So within paragraph 2 of the thing, it shows that this is a required direction. Now this is part of the update because it's clear that people were not following this properly, and so they're saying this is a requirement. It's not optional, you have to follow it, okay, and it can't be ignored. Okay, paragraph 3 shows that initially they tried to be non-discriminatory with this sentence: regardless of gender or sexuality, when they describe domestic abuse. However, within the document itself, they then go on to discriminate on many accounts. Yeah, so we'll run through it. Now, within the same paragraph, paragraph 3, they describe a new section called abandonment. Okay, and this is where the husband strands a foreign national wife. and then describes separation of the child from their mother. So they've clearly put down that to abandon someone, you have to be in a heterosexual relationship. Your wife has to be a foreign national. You have to go abroad and leave her there and remove the child away from her. So this one clause is clearly failing the Equalities Act on sex, sexual orientation, marriage and civil partnership, because you have to be husband and wife, can't just have a child together and live together, and even race, because your wife has to be a foreign national. So that one sentence is pretty hardcore discriminatory. So in paragraph 5, there's a very worrying assumption that they make, again, similar to what CAFCASS have made, that the parent with whom the child lives, i.e. the residential parent, is not the abuser. And therefore, the other party, generally the non-residential parent, is the abuser. So, and it's quite clearly shown with this outtake. Any child arrangements order in place protects the safety and well-being of the child and the parent with whom the child is living. So that's clearly defining that the one being abused is the one that the child lives with, and not the one that the child's not living with. Yeah. And so, using a heterosexual relationship, generally this is the this is mother, and therefore generally using a heterosexual relationship, this is clearly putting down that whole socio thing again about where there's an unreasonable expectation. There's a criteria, yeah, because the parent with whom the child is living was decided by the court by this predetermination earlier, and due to the status quo and the social assumptions that happen, that is generally the mother, and the non-residential is generally the father. So they're basically trying to imply that the non-residential, which is the father, is the abuser, and the residential is the mother. So, but I'd also like to point out, it's making quite a lot of news at the moment. Parental alienation, yeah, which is a form of child abuse, according to the head of CAFCASS, where one parent tries to turn the child away from the other parent. Used to be described as implacable hostility and that, but the courts are starting to recognise it. It's been recognised in other countries for quite a long time. But generally, the person that is causing the abuse in these situations is the residential parent, and they are trying to turn the child away from the non-residential parent. And the child, obviously, because they spend all the time with the residential parent, obviously in a form of self-preservation, has to comply with what this parent is making them do to the non-residential parent. So, I mean, often these children may have witnessed the non-residential parent actually being domestically abused by the residential parent, and therefore they've also witnessed the abuse, and the whole Practice Direction 12 clearly shows how damaging that is to witness such abuse. So, paragraph 6 shows that the court is dependent upon CAFCASS, and I've already highlighted the failings on their resources on that, who have spoken to the parties and performed safeguarding checks. But so there's a serious problem here. They are making it a requirement to use CAFCASS. CAFCASS's resources are discriminatory. Therefore, the court's going to discriminate because it is provided with discriminatory evidence. It has to deal with the evidence it's provided, and by using a source which is discriminatory, it's provided discriminatory evidence which is biased, and therefore it itself will discriminate because of its agent or employee, you could say. So they are therefore guilty by association. I believe in the original Sex Discrimination Act 1975, there was a whole section about a company is liable if the employee is sexually discriminative. Yeah, and I believe somewhere within the Equality Act 2010, similar will apply. I haven't necessarily found the exact terminology. It's very long and complex, and the terminology is quite oldie English at times, and But I'm pretty sure that, although the Sex Discrimination Act was repealed and replaced by this, I'm pretty sure that sort of function will still be within the actual legislation there. So, so for clarity, here's a line from PD 12J, paragraph 6. All initial safeguarding checks have been obtained by the court, and an officer of CAFCASS or CAFCASS Kimru has spoken to the parties separately. There you go, so they've been instructed. Now, in paragraph 16D, it sets out there should be the consideration of a domestic violence perpetrator program, a DVPP. However, as I've established from the CAFCASS resources, these are only available for men. Therefore, the court is saying it should consider whether this discriminatory act should be used, because it's only available for men. So, again, it sounds like they're implying that the perpetrator is a male, because they're saying you should use this, but this is only available for men. And so, clearly, if they're going to recommend to use certain programs and resources, they need to have a fair division of service, yeah, and provide equal service to both parties, not having barriers to entry. So, paragraph 17A specifically requires the views of CAFCASS. But this is just adding problems to the system, given the fact that I believe there is an institutionalised discriminatory within their system, and their resources are discriminatory in their manufacture, and therefore the results will be discriminatory. And so any conclusions drawn from them will clearly be tainted by this discrimination. 17C is talking about legal aid. Now, this is quite an interesting subject, the legal aid. So it's trying to say, to prove that there was domestic abuse, one of the steps of proof is to use the evidence that someone might have received for legal aid. However, actually gaining legal aid requires a lot of evidence, and often this means having to go out and get other service providers. Now, the problem is, these other service providers are also being highly discriminatory. For example, there's a major lack of refuges for men, yeah, and the female refugees do not accept the men, yeah, because they're trying to protect their female occupants. So, if you're domestically abused, you're supposed to go to a refuge, but there aren't any refuges for men, or very, very one or two, yeah, or but if you try to go to a refuge for women, you're not allowed because you are a man, and they're trying to protect the women who were abused by men. And so the councils, by not providing these refuges, are discriminating on their provision of service. And so this is clearly a lack of local authorities, but it is filtering into the courts, because you can't then give a letter from a refuge saying, I applied. And so I have actually done my own inquiries back in 2014 regarding refuges, and was quite shocked at these sort of things, but clearly I can't just say that. So what I have done is I have managed to find some information to help back this up. So there was a report that was produced by an independent charity called Parity, which is trying to make things even for both men and women. What they did is they used the Freedom of Information Act to gather all the data they could from all the respective councils, yeah, and they produced a report. Now, I think it's quite, please read the report. I've included the report again within the appendix. It is quite shocking. So, one of the tables is here. And as you can see, where it says the refuges, the ones provided for both males and females is tiny. I think that's a 3, so 3%. And the refuges just for women is 79%. So I've highlighted them to make sure females, the big one. Yeah, so this table does show quite a lot of the problems. So, just so you know, this was information from 2014, I believe. I will have to double check that, but it's in the actual document attached. But more recently, there was a BBC News article that was published on the 16th of February 2017 that shows that male victims were being discriminated against by local authorities by providing different levels of service based on the protected characteristic of sex. And I've included a copy of that BBC article within the appendix also. So this all then has a knock-on effect with the ability to even obtain legal aid. Yeah, so you can't go to a refuge because you were domestically abused, yeah, which means you can't then go to legal aid to get legal aid to help fight with the problems within court because you weren't accepted into the refuge. The problems are just mounting and mounting. So, and that then means that you can't then use the proof from gaining the legal aid to then provide that towards the family court to help show that you were domestically abused. So it all filters down, yeah. So the courts are suffering on this respect because of discriminations elsewhere. So we've got local authorities which have discriminated, which has affected the court as well. We've had the CAFCASS, which has discriminatory things, which is affecting the court's out process. So we move on to paragraph 25, which is all about restricting the contact with an abusive parent. But again, this has clearly been written on the assumption that the parent the child is living with is not the abuser, yeah, which is not always the case. So by making this initial assumption, you're putting the children at risk. You are putting them in harm's way. Their welfare is not being looked after. Their best interests are not being looked after because you've made an incorrect assumption at the very beginning. Yeah, and as I have said, I believe that this could also be linked towards the parental alienation as well. So the reason I make this link is I personally see a strong correlation between the two problems. Domestic abuse is about control over someone else, not having things outside of your control. Yeah, parental alienation is about controlling your child and controlling how they interact with the other parent. So people might be seeing them as disparate problems, and in some cases they more likely are disparate, but I think there's quite a strong correlation because the driving factor and force behind all of it is all about control. These people are control freaks, and that's really where a lot of it all falls apart. So these people are then able to influence and coerce the children, and although children, because they're under 16, aren't specifically protected under the domestic abuse law, it is somewhere covered within the child abuse section, I believe. But this influence and coercion of parental alienation is therefore tantamount to the coercion which is in a domestic abuse situation. But once the children get over 16, then they could use the domestic abuse situation, because that legislation came in on the 29th of December 2015, but unfortunately it's not retrospectively applicable to most people. Well, it's not retrospectively applicable, so if you were abused before that, you can't use it as a criminal offence. You can only use it as a bad character witness, as it were. So they would have to further abuse you afterwards in a way that you could record it twice more. So, PD 12J paragraph 34 again gives importance to CAFCASS and the DVPP, the Domestic Violence Protection Perpetrator Programme, which, as commented earlier, are both failing to comply with the Equalities Act 2010, and so the court is by virtue continuing the discrimination again throughout the document by recommending this particular programme. In paragraph 36, it makes the dangerous assumption yet again that the residential parent is not the abuser, which is indirectly discriminating against the I can't stress how much of a dangerous assumption to our children this is, and it is putting our children's welfare at considerable risk. Just to make it very clear, I think it's very, very clear with this little outtake on paragraph 36. The parent with whom the child is living will not be subjected to further domestic abuse by the other parent. What about the parent the child isn't living with? So it's okay for them to be domestically abused. Is that what we're saying? So, in conclusion about the family courts, I think it's quite clear that Practice Direction 12J, although it has recently been overhauled with the COB review, is failing on the Equalities Act 2010 by its recommendations, by the use of other organisations and requiring information from other sources which are inherently have discrimination within their systems and their resources. So, this way the Act is directly and indirectly discriminating on a number of fronts, but particularly sex, but as we noticed early on, it's also done it on your race, because you had to be a foreign national wife, and also whether you're married or not, because you had to be husband and wife in that abandonment. And obviously if you were just a mother and father and you were never married, then that would not apply. Well, at least that's the way it's worded in the terminology. So, I think it's quite dangerous about the way it has dictates that CAFCASS is supposed to be used when considering that the resources that CAFCASS are using are so discriminatory. Yeah, and the other third-party information such as the legal aid, which is then requirement on other discriminatory services. So it is very disturbing. It's disturbing that there is a major underlying assumption within this practice direction that the victim is the resident parent and the perpetrator is the non-resident parent. And this clearly is putting the child's welfare at risk. So I don't think the courts intentionally meant to breach this Equality Act or to put the children at risk. After all, this is supposed to be what they're doing to protect them. So although it's not intentional, that's not the point. You don't have to do it intentionally to breach the law. Yeah, just by manner of doing it. If you were driving along and you didn't notice that you all of a sudden got to 80 miles an hour and you were in a 70, you'd be breaking the law. You didn't realise, you didn't intentionally do it, you still broke the law and you'd still be prosecutable. Now, I think also that because of discrimination and the manner in which a lot of the people within the system act within the carrying out of their duties, that it creates an intimidating and a hostile environment, which is therefore harassment. Yeah, I'm sure if you interview those people who believe they've been discriminated against, they would describe this as their perception of the whole process, and that they would think that it was unreasonable conduct of the courts, yeah, and for the whole process. So this would therefore breach the Equalities Act, paragraph 26(4). These views are, however, officially gagged by the system of the private law, by the system of the cases being private law, and therefore you're not allowed to talk about your individual cases. But there seems to be many blogs out there, rights groups, who report such sentiments on the internet. It sometimes makes regional news and even national news and TV broadcasts. The bit that I remember many years ago now was there was this rights group, I think it was Fathers for Justice, and they used to climb buildings in their superhero outfits, and I thought they were complete nutters. And I thought that I honestly thought clearly there was something wrong with these gentlemen. Yeah, I thought, it's the law. It can't be like this. Perhaps my views are starting to change after doing this analysis. Perhaps these men were just very, very frustrated. This analogy might go a little controversial. The year at the moment is 2018. 100 years ago, in 1918, women managed to get better equality because they started to get the right to vote. So that was an act that got passed, and so women started to get the right to vote. And they were, a lot of that was thanks to the suffragette movement, who were militant in their cause, and they broke the law regularly, trying to bring it to the public's eyes. So I used to think they were nutters. Now, to be honest, I think of them as possibly a bit like the suffragettes. So, but that's what happens these days. You can look back on things that happened in the past, which at the time was more than likely you thought was not correct, and I honestly thought these guys were nutters. There's obviously also, it's quite clear that the law system, the courts are starting to understand that there's this such sentiment. I mean, at the very beginning, I have said how the President himself has made it clear with that opening statement that there is a widespread distrust in too many quarters of the competence or even the integrity of the family justice system and the professionals involved in it. Wasn't so long ago also that the ex-MP, Anne Widdecombe, also made public statements and media statements, and she said actually she believes men are discriminated more than women. Yeah, and there's an interview of it published in the Telegraph on the 30th of September 2016. A link again is there, and she's actually specifically referenced where she thinks the family courts are an example of such discrimination. So clearly, if you think there's discrimination, you're not alone. There's a lot of people out there that think that this system is discriminatory. I think I have done a reasonable review and analysis of the publicly available information, not using any personal information on here. This is all to do with what's publicly available as a review. I'd also say that I believe many of those who are discriminated against would fear in bringing this up as an issue, in fear of the fact that they feel they might be then victimised, or if they did have the courage to raise the issue, they would then be victimised for doing so. This, of course, I mean, as by the Equalities Act 2010, paragraph 27(1), where the discriminated against are subject to a detriment. Now, to many, it might be unclear of what constitutes a detriment, but it could be something that is quite small and quite incidental. Often it is just the manner in which someone then interacts with you. For example, in employment law, they give quite a lot of good examples. I think one of the examples they give is, say you are a female and you work in a heavily male environment, and they have a calendar on the wall showing scantily clad or naked women on the calendar, and you make a complaint about that, saying you think that is sexually discriminating, and it gets taken down. The fact that then afterwards these people that were the employees get umbrage about the fact that their calendar has gone down, and they then no longer talk to you. They shun her, or short, sharp answers, and she feels that she has been then victimised. And that is then considered she has been victimised because she has voiced her opinion that she thinks that this was sexually discriminating. So it's literally how other people then interact with you can determine whether you feel you have been victimised and the way that you are then treated afterwards. So this could then, in the family court situation, it could be how a CAFCASS officer, a judge, or anyone else involved with any of the organisations concerned then interact with you after you've raised these concerns. I mean, it could be simply the fact that you raise an issue and they just dismiss it out of hand, yeah, without a sound reason, which is then a reasoned argument, which is irrefutable, yeah, and then without recording the arguments for why they would dismiss, or why your concerns were ignored, or why they think they were incorrect. Yeah, that could be considered a form of victimisation, because you made a genuine concern known and it was gone, looked over, ignored. The fact that you are ignored would then be a form of victimisation. Therefore, this makes the individual a victim on two fronts as well. Firstly, by being discriminated against in the first place, and then because they actually mention it, they're then victimised afterwards. So, within the various bits before this, I have talked about how Practice Direction 12J was recently reviewed, and it was called the COB Review. And that I now just want to run through the COB Review itself in the next section and explain how I think that some of these instances may have happened on the section. So we'll move on to that in just 1 minute. Right, hello there. Now I've been talking about discrimination within the family law courts. I've talked about CAFCASS. I've talked about Practice Direction 12J, and in it I mentioned that this was recently reviewed in what's called the COB Review. So I've done a little bit of analysis and research into this as well. So many might not be aware that the Practice Direction 12J was actually republished in October 2017 after a review by a very senior and well represented family court judge, the Honourable Mr. Justice Cobb. It is unfortunate that even he was so indoctrinated by the system and the institutionalised discrimination that exists within it, that he was blinded to the issues I've raised about breaching the Equalities Act 2010. Basically what I'm saying there is, I've just highlighted a load of breaches within the PD12J. He put a load of recommendations in for it, and obviously not all of them were taken up, and there was various issues because basically the breaches have actually managed to filter through. So I also believe that this issue was compounded on the fact that there was a very, very large input from Women's Aid during the review, and there was no equally balancing representation from a man's focused charity. I do, however, think what actually should have happened really is, instead of a specific group charity working on it, possibly one such as Parity that I managed to get the research for previously, which is trying to do equality, should have been involved, but it isn't the way. It was heavily done with women's rights groups, and there was no men's rights groups to help further to balance the argument, as it were. So, as I've said previously, don't get me wrong, Women's Aid, you do a great job for many, many people, yeah? And as I've said, I've had friends you have actually personally helped out, and I'm very thankful to you for that. However, I do think that because you have a sole focus on the woman as a victim, this sort of distorts the picture, and the fact that you're only ever dealing with the women as a victim, your employees and that have a rather blinkered view of the world necessarily, and then they affect everyone else. And so I think as an organisation you need to be more socially responsible in your recommendations and your publications. I understand you're trying to aid women, fine, but you're having major influence on legislation which is affecting both genders. Yeah, please, let's protect everyone. Yeah, and the courts are primarily to do with protecting the children, and by promoting contact with an abusive woman, yeah, away from a non-abusive man, is clearly not in the child's best interest. And I know that's not what you're trying to do, but what I'm trying to say is the knock-on effects. And as I said, I think you do a lot of great work. Basically, no one should be abused. Yeah, everyone has a right not to be abused. So, here we go. Where is it? So there's a load of, because they're constantly putting the predefined assumptions of the male as the perpetrator and the woman as the victim. For example, at paragraph 22 within the COB Review, they specifically refer to the mother-child relationship, which is highly discriminating. You could have said the parent-child relationship. Why has a mother-child relationship got a priority over a father-child relationship? and of course it being non-sexually orientated, as in just genders, single-sex couples, one could be the mother, one was obviously not if you were two women, or you could be adopted and then both of you are men, and so that's I think is an issue. But what I think's really even more problematic with the COB review is then at paragraph 23 there's a blatant copy of the word mother. Now, I know Women's Aid, you're promoting the woman, great. But the COB review, at that point, they should have said, great, they're promoting the mother and we need to say the parent. So, I think that should have been reworded to parent-child relationship. And that was the responsibility of that part of the author on that section. So I'd like to point out in the actual COB review itself, Women's Aid or Rights of Woman, these are the women's charities, which I'm saying having a large influence, they are specifically referenced 28 times within the COB review. However, there is no reference to any male charity. So I think that quite clearly shows the distinct influence and bias in one direction. So it's not unsurprising that there is an unbalanced input in its production and in the final recommendations, which then happen. So don't think it's intentional, but if you're only ever hearing one side of the story, you've only got one side to balance. And so the APPG also give a one-sided comment, so they're mentioned within here, from saying when they interviewed victims, they specifically said at paragraph 13, the APPG makes a similar point referring to routine experience of women being questioned by the alleged abuser. So, that puts the woman as the victim. Okay, they haven't said the alleged abuser is a man, but most relationships are heterosexual. Therefore, it implies the man's the abuser, but let's just say it's not. They're still saying a woman's the victim. Therefore, a man cannot be the victim. And as well, they also write, as well as being a traumatic experience for a survivor of domestic abuse, this can also mean that women feel that they are unable to advocate properly for the safety of their children, meaning that they and their children are denied access to justice. So, this also means that women feel, this also means that the victims, not also that the parents feel. Just because you've been domestically abused and you're a man, it does not mean that you do not feel you can advocate for your children so much. Yeah, if you have been abused, coerced, or put down, you're going to have confidence issues. Yeah, and it's going to take time and a lot of soul searching to be able to get over some of these confidence issues. And you're not going to be able to advocate especially when you first get out. When you first get out of a domestically abusive relationship, you are still heavily influenced. It's going to take the time to be able to recover from such incidences. So clearly they're assuming that the women are the victims and therefore it's discriminating on this basis. Because of the one-sided input, I believe the whole review itself is then flawed because it's only focusing on the one segment of society, i.e. the women, that accounts for approximately 50% of the population, let's say, if you're saying there's equal men as women. This is therefore had the repercussions. This therefore has repercussions on the innocents. And the innocents, I mean the children. So you're applying these specific criterias, and it's the children that are suffering, Yes, the victims are suffering as well, but the court's primary objective is the child. The parents are secondary objectives. The main objective of the family court is the child, and by discriminating, you are discriminating by proxy the child and you are putting the child's welfare at risk. So, in my final conclusion, I think there's irrefutable evidence that there is, to some extent, the existence of an institutionalised discrimination, just from the resources that I've managed to pull out. Yeah. So if it's made it into these publicly available resources, where does it lie in the stuff that's not publicly available? Where does it lie in the conversations that happen behind closed doors? There's a lot of stuff you can't do, but the sheer fact that it's accepted to such a level, it's made it into their publicly available resources, they don't see anything wrong with it. I think that just shows that there is an institutionalised level of it. I also think a much bigger part of this problem is actually discrimination is much more widely spread. Yeah. So as I've touched on previously, I believe there's issues with the provision of refuges, which comes down to the local council and the legal aid systems. I'm pretty sure that if you manage to talk to people who are discriminated against, yeah, they more than likely say there are other institutions which are discriminating against them, yeah, such as possibly the schools. I mean, on a split family, are you being treated the same? So are the two parents being treated exactly the same? I'm pretty sure you will find most people, if you ask them about that, they would say, no, we are not being treated the same. Possibly some's getting more information than others. People are getting more opportunities. I think you might find that with other organisations, schools, for example, I think with medical records, they will often ask to see whether you have parental responsibility, and the assumption is that the mother has parental responsibility, but the father has to prove he has parental responsibility. Therefore, you're setting a criteria to him which you didn't have to apply to the other. And so, that is, of course, bearing in mind the fact that mothers do technically get parental responsibility initially, but if they are deemed bad, you can have your children taken away from you by social services, and you can have your parental responsibility for that child revoked. Therefore, why would the organisations not insist on everyone being able to prove that they have parental responsibility for that child? Because their parental responsibility could have been removed, apart from it never being there in the first place. So, and I think also, just to compound the problem even further, I think society itself is being discriminatory at a subconscious level. I believe recently in the news there has been a major issue on a gender pay gap, as it were. And there wasn't any real evidence as to why there was this gender pay gap. And I think the final conclusion was they're not saying there is gender discrimination on pay, but they can't say there isn't. So I think this is a much more societal level. Yeah, I think it's very well portrayed. There is a YouTube video which is called, and it's got a hashtag reference, "Violence is Violence," all in one word with capital V, capital I, capital V. So violence is violence. Okay, and this shows how the public react totally differently to the same situation. There's a couple, a man and a woman. At first, the man is basically abusive towards a woman, and the public all jump in and all go and save him. They go and save the woman. Yeah, people step up, people confront the man. Later on, they do it. It's in the same setting. These are the general public. It's two actors, but general public. The same two actors then have the situation, and the woman is abusive to the man. Yeah, she pins him against the fence and everything, and all the public does is looks, laughs, photographs. No one intervenes to protect him. And so I think that just helps to show it's much more a societal thing. It's not just a cult. Yeah, and at the end of that video, particularly, they make a claim that 40% of domestic violence is suffered by men, and they quote the source as being the National Statistics Office. but I haven't managed to go on there and find that and validate that. So I'm not saying that is a true statistic. It is what they put on their video. I'm pretty sure they most likely have qualified it, especially as they've given out a source of it. So they'll most likely have on record that source and a copy of that information from whatever year statistics that was done. Because it does turn out, I found out after quickly Googling, the National Statistics Office does actually record these sort of statistics. So, for us to change society, I think what we need to do is we need to show that the law itself thinks it's unacceptable. And the fact that the law itself is actually breaching the law, yeah, with the Equalities Act, it's obviously not. Yeah, and by using organisations with CAFCASS with resources which are breaching equality, as far as I can see, yeah. So we need to ensure that we can't change it all overnight, but let's change what we can. Yeah, let's start with this section. Yeah, practice direction 12, CAFCASS. Right, let's focus on this. It's not going to necessarily help those that are abused as much. It's going to help the children. Yeah, and we can then help prevent future generations of abuse. Pretty sure those which see, witness, or are victims of abuse as children grow up to then be either victims or abusers themselves, because they see how the power ratio works. So we might not be able to fix all the problems now, but if we can start, let's focus on this section, and that would be a good start. Yeah, I do think the parent needs protecting too, but I'm going to go back to the fact that the overriding objectives of the courts is about the child. Yeah, and so showing that this is negative to the child, and they already know it is. They make quite a big thing about it being negative to the child within practice direction 12J. Therefore, hopefully this will get the message home. Okay, it's quite clear that actually what most people don't realise, that their overriding objective to protect the child is actually more important than justice and fairness. Yes, I have said this. Protecting the child is more important than one of the fundamental parts of our entire law system. So this is quite clearly shown in Practice Direction 12J at paragraph 31, that the detriment to the welfare of the child would outweigh the detriment to the fair trial of the proceedings. So there we go. In black and white, in legal defined documents, they are saying the welfare of the child is more important than the other aspects of the law and justice. So that's my conclusion on there. So now I want to just say that I have done this, yeah, because I feel that the family court system isn't protecting the children to the extent that they should be, and the services are not protecting them that they should be. I am a father. I have a great time with my daughter. I have a relationship with my daughter which most or lots of people would envy. Yeah, so let's not get this wrong. I spend a lot of time with my daughter. I have great contact. We go on holiday a lot. Great. Yeah. I am just concerned that there was 40,000 odd cases in that 1 year. Yeah. There's a lot of children out there which are not being protected in the way they should. Yeah. And it concerns me. And so these innocents need protection. Yeah. I have had at no time prior to this or at this moment in time any affiliation with any rights group. I'm just a concerned father, but I have started to sympathise with some of the issues that some of them are trying to raise. I would like an open and public response and debate about this. I think these organisations should do a little bit of soul searching. Yeah, I don't do this for any fame, money or anything. This is to protect the children. I would quite like people who have an intricate knowledge of the Equality Act 2010 possibly to have a look through it. I mean, if people think that what I've said is a misinterpretation, but because I'm not legally trained, yeah, but this is how I've read the legislation, this is how I believe it's supposed to be enacted, and this is my review of it, okay? I do hope that me voicing my concerns about this discrimination means that I'm not then going to be harassed or victimised for me doing this. Yeah, I'm trying to protect the children. I would very happily talk to the President, Sir James Mumby, yeah, because I would like to ensure that these issues are resolved, and that, I mean, I'm sure he'd be able to find me. I'm not that difficult to find. So if you are a parent, yeah, even if you're not a parent, you might be a parent one day, you might have grandchildren, this affects all of you, yeah. It might not necessarily affect you, but your child, your grandchild could get affected by this, yeah. So I don't want people to think this is just for men, as it were, because clearly I see quite a lot of discrimination on the basis of sex and sexual orientation within these resources, but I'm sure mothers, grandfathers, grandmothers, yeah, you all want to look after your kids, yeah, and your grandchildren. So if you like this and you think there's some validity in it, share it. It's not going to be that that difficult. There's a little button on YouTube where you just hit the share button. Yeah, I would really like, I don't know how to get it to the President of the Family Court Division, so be nice if he sees this and would like a discussion. Yeah, I'm only doing this because I want to make sure the discrimination is gone, because the discrimination is not putting the welfare first. So if you like this, please share it, give it a big thumbs up, and yeah, let's see if we can make 2018 a better, more equal society, 100 years on from when the women managed to start their process for getting the votes. So perhaps this is 100 years later, this will be the start.